I have an exhibit I use in all of these cases, and I call it Elon's greatest hits. It is his greatest hits of misinformation, disinformation, misrepresentations, and outright lies. And I play it. And, there was once a time Tesla would even deny that he had even made these statements. And then you bring multiple motions to compel. And now they have gotten to the point where they admit that he said these things as a corporate agent for Tesla. And the reason they have to do that is because if they don't give me that admission, as they've now been told by multiple courts in multiple jurisdictions across America, well, Schreiber's going to have to take his deposition. And they don't want that.
Yeah. Have you taken his deposition? Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited for this after-action review, where we sit down with Brett Schreiber from Singleton Schreiber. We discuss what it took to achieve the first jury verdict against Tesla, and what a verdict it was.
What this case was the first third-party Autopilot defect case to go to trial in America. And what that means is this was not something where the plaintiff was the driver of the Tesla on Autopilot. This was a young couple, 22 years old and 26, who were minding their business at the end of a T intersection in Key Largo, Florida, having lawfully parked beyond the edge of the road behind some signs, and had done nothing other than go fishing that evening, and were packing up, looking at the stars and talking, when a Tesla on Autopilot drove through that intersection, through that stop sign, through the flashing lights and the signs at over 70 miles an hour, colliding with them, causing the 22-year-old young woman to lose her life and her 26-year-old boyfriend to be forever injured. So that, in a nutshell, is what the case was about.
Help us understand how you took what you've just described and picked a jury, got the story told, and any of the pivotal moments that unfolded in the courtroom that you feel helped the jury really understand the magnitude of the harm and why Tesla really had to be held accountable for this.
So a couple of things. Set the stage. It's July in Miami, Florida. The first thing I did was purchase 2 linen suits. I needed some breathable fabrics if I was going to actually. And I grew up in the 305. So in some ways it was a bit of a coming home, but I left 25 years ago. We're in federal court. Beautiful courtroom. But it's a federal courtroom. The judge is, 15 feet up in the air, 100 feet away. And folks show up for jury duty and begrudgingly gave us a modified jury questionnaire. She had a very truncated one that would have been effectively meaningless. So she agreed to some minor modifications. And we got a stack of 100 jury questionnaires as 100 jurors walked into the courtroom, which for anybody who tries cases knows is a really rough spot to be in, because we like to ask the court to let us have the jurors fill out the questionnaire and then maybe, give us an hour. Overnight would be amazing, but a lunch break to review the questionnaire so we can ask for meaningful follow-up. Yeah, that wasn't a thing. So 100 people walk in with 100 questionnaires and we just start powering through. And as they're answering questions and the judge is doing her follow-up, I literally managed to get through the stack as she's finishing, an hour and change. And I'm just boat racing through this thing and just making a couple quick notes here and there. And, one of the things I'm sure you've talked about with others, but they don't really teach you in law school, is that, jury, that doing of voir dire, while it is obviously important and you have to have, kind of approaches and skills with respect to engaging people, you also have to be pretty good at arts and crafts. To convert all of your pieces of paper in a way, because this was a courtroom where you had to voir dire the whole 100 at a time. So again, really meaningful conversation when you're talking to 100 people at a time and given 30 minutes to do so. And what I really loved, a story within a story, is I finished taking notes of the last person's thing. And I'm scribbling, scrambling, going through the questionnaire, listening with one ear. My local counsels are there. Our jury consultant's there. We're all, passing notes, trying to do this. And the judge finishes. And it was about 10:30 in the morning. And she goes, all right, Mr. Schreiber, you can, inquire of the panel. I said, well, Your Honor, I said, I know you had mentioned wanting to have, restroom breaks, twice, in the morning and the afternoon. Would now be a good time? No. It's like, can I get a minute to and I don't have a minute. My stuff is all over the place, right? Like it is not nearly as coherent as I would like, but whatever, you got what you got and you get what you get. And, as I tell my kids, you get what you get, don't throw a fit. Right. And, so I didn't throw a fit. I stood up and I went. And we had some decent data points from the questionnaire and, we got people engaged. What was cool about this one was, this case was a big deal. People knew it was a big deal. And so it was definitely one that wasn't met with a lot of, arms crossed and what the hell are you wasting my time here? This was one people actually, one question I always ask at the end of voir dire is who here wants to be on this jury? And I had more people raise their hand in this trial than any case I've ever had.
I want to ask you why you asked that question.
Because it tells me something. It's a good data point. More often than not, I mean, does it identify some plaintiff jurors? Potentially. But depending on where they are in the shoot, I just find it's effective. It finds that people who is engaged. I want usually at least one or two people to be engaged, right? And I had a number of them that really wanted to be on the jury. We had and I tell them, I said, look, and I tell them that, and, I said, this might buy your ticket out of here. Right. But let me know. And I think it's a credibility booster, right? It shows that you really are listening and you want to know if they really want to be here, if you really want to be here. And that is, I will say, one of the struggles of being on a 30-minute clock is it doesn't give you the opportunity to build some of the credibility that you can if you have a 3-hour or 3-day voir dire. So that was a kind of a scary part of this because you're an inch deep and a mile wide at best. And then combine that with then rolling into opening statement, which I do that afternoon. I mean, we called them and paneled them and I think opened all in the same day.
That's a lot.
It was a lot. And it was also because I was then told that I think I was given an hour when I had prepared an hour and a half. And one of the things is this case, and I've had others in federal court have taught me, there's tremendous value actually in being on the clock. I think one of the strongest signs of good storytelling is when you've left a lot of good content on the editing room floor. It's probably true for podcasts as well, right? And I think the greatest anxiety that trial lawyers often have about trying a case is, I'm going to forget something. I'm going to fail to include some important point that they need to hear. But I think a lot of times that actually results in dilution. Right? You can drown the jury, especially in a case like this. You can drown the jury in too much information such that they don't know what's important. They don't know what to remember. They don't remember if they're going to remember some of it or any of it because it's so much.
I have to imagine that was probably part of Tesla's strategy. This is so complicated.
100%. 100%. That was, and it's all about a driver. I mean, and in a car, this is, God bless Tesla on this one. And they said, this is a case about a driver who was on his cell phone, who dropped it and was fishing around on the floor, which he was doing, for his phone. And they said, and this is also about a case of a car that never existed, that there was no car that should have stopped, warned, done anything, which again, thank you, Tesla, opened the door to my argument of you can't show up after saying for a decade that you've built the greatest autonomous vehicle the world's ever seen, and finally come into court and raise as a defense, admitting the fact that the car you claim to have invented never really existed. So that was a gift.
Yeah.
There was a lot of gifts that they gave us in that regard. One expert alone, by the time of his deposition, had billed $965,000. He was about $1.1 million by the time he showed up at trial. One guy. And, he went out and they crashed a bunch of cars and showed that, oh, well, the Subaru and the BMW and the whatever it was. See, we went out on our test track at Exponent, the doubt is our product people. And, none of these cars warned and none of these cars stopped. And so why would you expect the Tesla to do that? And, this is state of the art and all of that stuff.
But none of those are claiming that they are full self-driving and autonomous.
Bingo was his name-o, Mr. Cooper. That's exactly right. And I think that's where, again, the jury saw through a lot of it. As I told them in opening statement, they would have to make a decision. Was all this testing? And I'll tell you what, when Exponent drops that terabyte file on you with, these cars rigged up with all these sensors and GoPros and crash dummies, and it's impressive.
Yeah.
You look at it and go, oh,
yeah.
Wow.
Yeah.
But when you then dig into it, you have to ask yourself, as I told the jury, is this sound science or does it just sound like science? And it sounded like science, but it wasn't sound science. And they saw that. And then we were able to show that for some of those experts, at least early on, they weren't even given the data about how the crash occurred. And there's a funny story that's worth telling. We're about a week in, and one of the Tesla experts was on the stand. And there's this woman, she's one of our first jurors in the front row. She was a large lady, to put it gently. And so she didn't really use the table that was kind of on their little arm. It was almost like your kids' school table where there was a little kind of thing for them to write. And it's actually a nice courtroom. They all had their own individual screen and nice little setup. So they all had their little kind of pod that they were in and in the jury box. So she didn't use that. She would keep her notepad and rest it on her chest.
Okay.
Kind of using it as a little table.
Yeah.
And they're talking and Tesla's got one of their people on direct and he's talking about the information that, he had received and all of that. And we then get up and establish that, they had withheld this evidence and this was again where Tesla, they went a bit too far. Right. And so they go after one of our experts about whether or not they had received all of this data. Discovery abuse is generally not admissible at trial.
Correct.
However, if the defendant opens the door to the discovery abuse, you can get there. And so I'm sitting there and I've got this is one of our witnesses that's on the stand. And the day before, Tesla had gotten pretty close to allowing us to talk about it. We went sidebar and the court looks at us and says, no. They talked about it, but they didn't really. So it didn't get close enough. Next day, we got another witness on the stand. One of Tesla's blowhard defense lawyers gets up and is going after my guy about, did the lawyers tell you about the efforts they made to get the information? I look around and go, oh my God, they did it. So I get up on redirect and I say to my witness, I said, sir, when you were asked on cross-examination about the efforts the lawyers made, do you recall that? He said, I do. I look up at the judge. She's 15 feet in the air, 100 feet away. She looks back at me. We lock eyes. She gives me the chin up. She just tosses her chin up. Like,
yeah.
Go.
Yeah.
I said, sir, why don't you tell us about that? He had been prepped and he just riffs. He just vomits a 4-minute answer about all of their abuse. And my lady in the front row, who uses her breasts as a table, just starts furiously taking notes, and audibly she just goes, and that was one of the moments where I was like, I think we're going to be all right.
Yeah.
I think we're going to be all right. They're getting it. Because her and another woman, at one point, they were on with one of their witnesses. They were asking him about what he had and what he didn't have and whatnot. And she literally looks at the woman next to her, because we're talking about the stuff that they had sent the expert, which didn't include the data that we ultimately found. She literally looks to the woman next to her. She goes, I bet he didn't have the autopilot data. I was like, oh my God, did she just say that? And so again, they were getting it.
Yeah.
Right. And we were day 8, 9, 10, 12 at that point. And that, I got to tell you, I mean, look, you know, from trying cases, man, it's hard to read tea leaves, you know, and you know, when you look at them, are they smiling? Are they nodding? Are they not nodding? Are they paying attention? Right. There's a million things that you can kind of get lost in the sauce on, which I try not to do. But you can't help yourself when you're spending 8 hours a day in a room with these people.
A question that I have is, how did you handle the showroom versus the courtroom evidence? Was that through a person most knowledgeable? Because the juxtaposition there seems like that was very important.
Yeah, it was generally through. So what we had done is we had taken all of Elon's. I have an exhibit I use in all of these cases, and I call it Elon's greatest hits.
Okay.
And it is exactly that. It is his greatest hits of misinformation, disinformation, misrepresentations, and outright lies. And I play it. And, you know, there was once a time Tesla would even deny that he had even made these statements. And then you bring multiple motions to compel. And now they have gotten to the point where they admit that he said these things as a corporate agent for Tesla. And the reason they have to do that is because if they don't give me that admission, as they've now been told by multiple courts in multiple jurisdictions across America, well, Schreiber's going to have to take his deposition. And they don't want that.
Yeah. Have you taken his deposition?
No.
Okay.
Because I've gotten that close.
Okay.
Because I said, listen, Your Honor, I have to get an admission that he said these things and maybe even why he said these things. If they give me the admission that he said them, I honestly don't really care about the why, because it's not true anyways. So, but, you know, I need to get here. And so eventually I get very clean admissions. As a result of having very clean admissions, Elon's greatest hits, both in video and audio, become trial exhibits.
Understood.
And then they play just like with closed captioning so that everyone can read and see. And I get certified transcripts, and those get marked as exhibits as well. And so mechanically, that's how we put it into evidence. So Elon is perpetually testifying, and I use air quotes when I say that, throughout the trial. His presence is there without him being there, which honestly I've also found, certainly having seen the level of media attention that the case got and the trial got and all of that, it was important that he not be there, because it would have made it a goddamn circus. Mm. I didn't need a circus. I wanted, I wanted to push this thing through and, path of least resistance and put on a clean case and a short case and an understandable case. Elon would just be a lot of distraction and bluster and who knows, right? Who knows what he would say and how he'd say it. So having a controlled Elon Musk, which is just his testimony, which I would then play more often than not with my own experts and say, Dr. So-and-so, right? Computer vision, human machine interaction expert who's developed autonomous systems and vehicles. What do you have to say about Mr. Musk's statements? They're as untrue the day he said them as they remain untrue today, or whatever the response may be. And so that's how Elon was in the courtroom without being in the courtroom. And then in other cases, what I've established is, because I didn't get a chance to take as many of the Tesla employees in that trial as I have in other cases, but I play Elon's greatest hits for them in deposition. And then I ask them, is that statement that he just made true? Did that comport with engineering reality in production vehicles at the time? And to a person, they all admit, absolutely not. And what you really then get, Miami was a story of betrayal to the ordinary consumer. The case that I was going to be trying against them right now in Oakland was a story of betrayal to the ordinary consumer. It was another third-party case that has been resolved. But it was also a story of betrayal to his own engineers. And we all know one of the singular most powerful human emotions there are to empower juries to deliver justice is a story of betrayal. And when they find out that he's not only betraying the public, but he's betraying his own people, because they themselves know everything he's saying is bullshit. And I've watched, as I've shown some of these guys, some of the videos and some of the things, and it doesn't show up on the transcript, but it sure as hell shows up on the video. When you show it, this look of disdain, this disappointment, right? It's like, you're not mad at your kids, you're disappointed.
Yeah.
That's kind of the look that they give. Like, really? Really, bro?
Yeah.
Like, we're back here working our asses off and you're out there saying all this stuff that it's just not true. Most of the people at Tesla who have independent engineering judgment don't last. They leave or they get fired because they raise their hand, right? If you don't have independent engineering judgment and you're willing to simply genuflect to the dear leader and whatever his whim of the day might be, then you can have a long and storied career at Tesla. And that's just been a kind of a continued theme in all of these cases.
You answered my question about how you do the showroom versus the courtroom for a case like this. Were there other moments or pieces that you felt would be helpful for listeners to understand how you were able to achieve this?
Well, yeah, we were also very fortunate that we received, I guess fortunate is maybe a strange way to put it, but it is, a 96-page Daubert and motion in limine order before trial.
That's a comprehensive.
Robust, I think, to say the least. A very robust order from the trial court about why she denied their summary judgment on punitive damages, why she believed, certain, design defect claims could go to the jury, on what basis. And that really formed our roadmap in terms of the evidence that we put forward, right? Which she saw that we could do by way of our papers and then proceeded to do live and in color. And so, to that end, one of the things that the court latched onto, which so did we, was this thing known as the vehicle safety report. And Tesla, like other companies have done, touts its statistics. But it's the old Mark Twain. Lies, damn lies, and statistics. And so they have put out this report for years saying that Teslas on autopilot are safer than traditional vehicles. It's categorically untrue. And I'll spare you and the listeners a treatise on why the vehicle safety report has no math and no science behind it. But we had an epidemiology statistician expert who I put on the stand in 30 minutes, because nobody wants to hear from an epidemiologist statistician for longer than that, as to why there was no math and no science behind the vehicle safety report. And what that was helpful to was, Tesla continued to say throughout the trial, from opening through closing and everywhere in between, yeah, all this stuff about Elon, all this stuff about these reports that we put out, all this information, it doesn't matter. It doesn't matter. The driver never saw some tweet of Elon Musk. He never said that he relied upon some statement. He never went on the website and read the vehicle safety report. This is all a bunch of distraction. But they're wrong. Because the jury instructions ask about the expectation of the ordinary consumer, right? And that all goes to how they plant these seeds in the ether. And eventually they do get stated by Elon, but then they get published in news reports. Then they get retweeted on, Twitter. Then they end up in someone's mouth who passes it along to their friend. And then it ends up in someone's ear.
It's like a virus.
Exactly. And what this gentleman said is, while I cannot point you to any particular statement or word or phrase or tweet or report on a website, I can tell you, I believed that this system was better than a human. I believed that it was essentially going to help me and activate. I bought the car because I had a 110-mile commute from my office up in Boca and my second home in Key Largo, which I went to on the weekends, and I would have it drive me there. And I could take calls and do other things. That's what I did, right? Where did he get that from? Right. And one of the things that opened the door to really frame that at the end was, I was able to show, and I had a slide with, what was it? It was Chick-fil-A, the cows, Limu, the Emo, and Doug, Liberty Mutual Insurance, and the Geico Gecko. And I said, look, folks, you all know that Chick-fil-A's got a bunch of cows who want you to eat more chicken. And if you watch sports on the weekend, Limu, the Emo, and Doug want you to buy Liberty Mutual. And that Geico has a gecko that peddles their insurance. Now, you don't know the names of the CEOs, and I looked them up. I don't remember what they are. Bob Smith and Jim Jones and Doug whoever of these companies. But the decisions that they make and the words that they use influence and impact how the ordinary consumer interacts with and purchases their products. Words matter. Elon Musk is no different. He's putting this out there to sow all of these seeds in hopes that they sprout in the conscience of the ordinary consumer. And newsflash, it worked. It happened. And then they show up at trial and are like, but you see here in the owner's manual? The owner's manual says this is just an adaptive cruise control, requires constant human supervision. Which, again, thank you, Tesla, opens the door to the argument. You can't shout the claim and whisper the disclaimer. Because that's what they do.
Yeah.
They shout from the hilltops. This is the greatest vehicle ever driven. And then they show up in court. And they try to tell you, but look what we put on the 87th page of the owner's manual that no one reads, which, by the way, there also is no actual owner's manual in these cars. They live inside of the media control unit. You have to go through about 12 screens to even find the damn thing.
Yeah.
And one thing I didn't get to be able to prove in that case, but I'm working up in other cases, they have data as to whether or not someone has actually ever clicked through to the owner's manual. Because they track everything. They know whether your phone is plugged in and the charger and the temperature control in the rear passenger seat, at any point in time. And so that, again, it's Tesla in the courtroom and it's Tesla in the showroom, right? It's words matter.
We've covered a lot of the evidence piece, experts. Can you bring us to closing and, in essence, the moment of truth, the verdict?
Sure. Yeah. So, similar to being on the clock at the beginning, I was on the clock again at the end. And after a month of evidence, I thought taking a couple of hours to unpack it all seemed reasonable. The court didn't. I was given an hour. And I said, okay, seems a bit light, but I'll deal. And in addition, because I reserved rebuttal time, that came out of my hour, which I hadn't had a lot of judges do that before. Normally, I'd be given an hour, defense would be given an hour, and then I get my 15 minutes. She's like, no. That means you got 45 minutes and save your 15 or whatever it was. Maybe she gave me an hour and 15 and I saved the hour, whatever it was. It was about half of what I thought I needed.
I should have asked this question before, but I presume federal court, it was a chess clock. Did you have 50 hours to try your case?
Not quite the chess clock. Been on the chess clock before. This wasn't that, but this case is done by this day.
Okay.
You're going to be doing, these are the hours we're going to be in. You're going to get all of this done. She wanted the full schedule like a week in advance, where it was shared with everybody. So none of that, like, oh, I'll tell you who my witnesses are tomorrow kind of thing. She ran a tight ship.
Okay.
And, it was Judge Bloom's world and we were all just living in it. And so again, in that vein of being afraid that you're going to forget something, being afraid that you're not going to cover it, you leave good content on the cutting room floor. And so I really kind of embraced that. And secondarily and uniquely to Florida jurisprudence, I was given a video that was put out by an appellate lawyer through one of these trial school groups. And it was an 1.5 hour long video that I needed to watch the weekend before closing, where she went through all of the ways you can commit prejudicial attorney misconduct in Florida, which shockingly was about 80% of the things that we use as argument in California results in mistrial in Florida.
Fascinating.
If you talk about the value of a life and you compare it to a painting, you compare it to the stealth bomber, you make reference to how much, Manny Machado gets paid, you mistry your case.
Wow.
That is prejudicial attorney misconduct in Florida. There was a multitude of things that I would routinely have argued and really in fairness, and I think one of the takeaways from that was what I realized is those are my crutches. I have certain crutches that I rely upon after, trying a couple dozen cases. You got stuff that, it's just kind of some of your prepackaged stuff. And I had to leave 80% of it at the door. And I'll tell you, it turned out okay.
Seems like.
Yeah. So, made me realize that maybe that admittedly schlocky prepackaged stuff that it really is, because it's just the same thing. You're just applying it to the new case. There's nothing wrong with leaving some of that stuff at the door, right? Maybe you don't actually need those crutches. Maybe you don't need to worry about introducing and talking about every damn bit of evidence that came in as you go through the verdict form and show the jury all the ways that it fits into it, right? If the case is properly presented, if your jury's tracking, you can come out all right on the other side. And that was, I think, a couple of the big lessons of this close. And the last one where I want to give attribution was on arguing punitives. And I picked up the trial guide's book on punitive damages. And a friend of mine, Sean Simpson, and some others collaborated to put that together. And one of the things that I took from it that I used in the punitive damage argument in closing, and this was no bifurcation, so it was all in. So they made their rulings about design defect and damages, and then was it malice, was it wanton, was it reckless, and then if so, what are the damages? So it was an all encompassing punitive.
45 minutes for all of that.
For all of that, and so I was given and I ended up landing the plane like 3 minutes early. I ended up having 20 minutes in rebuttal, which I ended up not using. I used like 12 of them or something. So I ended up actually leaving time on the clock.
Okay.
Which I would not have expected. But again, trust your instincts and hopefully trust that the case has come in the way you hope it has, and they'll do the right thing with it. And one of the ways I was able to reframe punitives is, of course, I talked about it with the jury instruction that it's to punish, right? But I really talked to the jury more. I said, I know that's what the instructions say, but I want you to realize that this is actually an opportunity to help Tesla. When a company has lost its way, when it has decided to elevate profits and greed over life and safety, it is a company that is off the rails, and it needs to be brought back. And through your verdict, through these punitive damages, you can tell Tesla to stop doing this, to be a better version of itself. Now, the reality is, it is an incredibly loathsome company led by an incredibly loathsome human being who I don't actually believe learned anything from this trial or will learn anything from any amount of punitive damages. That said, I still believe that the jury could be more essentially empowered to come in and award punitives if they knew that there was something that was coming out of it more than just smacking their hand.
That makes a lot of sense.
And so, the thing about Tesla was they had filed their Q10 with the SEC the Wednesday before closing. So I was able to use that as evidence of value. And they had $77.3 billion cash on hand. With market capitalization, they're $1 trillion company. But in terms of actual value, taking the market out, they had $77.3 billion. And so it opened itself to a very simple argument, which, again, giving attribution, goes back to the old Brian Panish in one of those Ford cases that he got a giant verdict on, where I said, look, folks, $77.3 billion. It's been, and I'm making up the number now, 2,289 days since this accident. And as a result, Tesla has acquired $36 million in wealth every single day since this incident occurred. And I would ask that you just dock them 1 week's pay. 1 week's pay was $230 million. I asked for about $104 million on the compensatories for the injury and for the death. And in the end, they actually they gave me $129 million in compensatories. They went $25 million over my ask. That's never happened before.
Yeah, that's something.
I've had one time, I think a jury gave me more than I asked for by an order of a few $100,000. And then they gave me $200 million in punitives for a $329 million result. And I mean, wise man once said the closest thing to free speech in a courtroom is a closing argument. I would caveat that to say the closest thing to free speech in a courtroom is a punitive damage closing argument.
Yeah,
against a giant $1 trillion corporation. It was a beautiful thing to be able to even be a part of, and then they got it, and the jury had the case for 5 hours. And then we received the greatest jury question in the history of jury questions. How are the punitive damages divided amongst the plaintiffs? And what it showed was the jury was thoughtful. They had just gone through the verdict form in 5 hours, and they had answered all the questions. And they had given a certain compensatory amount for injuries and for death. And then they had done apportionment between the driver and Tesla, which they put a third on Tesla and 2/3 on the driver. I said it was a chicken and an egg, but it's all about shared responsibility, right? That was the whole theme. The case was always about shared responsibility from the jump all the way to the very end. And they got it, but the punitives are awarded solely against Tesla. So, but then they got to that last question and there was only one line. And they're like, why is that? And so they were being thoughtful. Now, I've tried enough cases to know I don't really read into jury questions. I read into that one.
Yeah, that one's pretty clear.
I was pretty clear where we were on the verdict form and what was about to happen. And to this day, it's never been explained to me why someone didn't get Elon Musk on the phone and say, we need a $100 million cashier's check delivered to the Miami Federal Courthouse, and we need it here in 5 minutes.
Yeah.
Because this thing's about to go boom.
Yeah.
And they didn't. And it was the first time, as we sat out in the alcove outside of the courtroom after that question, where I gave myself and my co-counsel the space to look at each other and go, it's happening. It's really happening.
Did the defense team even approach you after that?
Shockingly, no.
Wow.
And they were all there. General counsel, director of risk, they all were sitting there on the other side of that alcove. And not a one walked over. And we just simply huddled and hoped. And 10 minutes later, knock on the door, we have a verdict. Like I said, turned out okay.
So what I understand from you, because I asked during a break, is that you are not allowed to speak with jurors in Florida. So you don't have polling data or information about that.
No, that's another little known codicil of Florida law. When I asked my local counsel, because I had my team, we have certain processes in place. I have a juror feedback form, and I had my team prepare it, and we're ready to send it out. And they're juror feedback. They're like that's a bar violation. It's like, really?
I'm not a member of your bar.
Yeah, exactly. I'm an honorary member. I'm pro hoc, but so no juror feedback.
Yeah,
and so they split, and they're in the wind, never to be heard, from again. If by chance any of them are listening, I just want to say thank you. Thank you for your service and and sending the message that needed to be sent.
And then as far as just bringing our listeners up to date in terms of where things are, sounds like all post-trial motions
are fully briefed.
Okay.
We're fully briefed on post-trial motions, awaiting a hearing if the court's even going to issue one. Nothing in the post-trial motions were surprising, nothing that they hadn't already raised. So unless the court makes an about face on some issues, which I think is improbable, but you never know, I think we'll be okay there. And then up on appeal to the 11th Circuit. And the focus of that is all going to be on both entitlement to punitive damages. There's a half-assed attempt at arguing the due process. But I say it's half-assed because, Florida has a limit on punitive damages. It can only be 3 times compensatories. However, you can't tell the jury that. If you tell them that that's what the law is, you commit prejudicial attorney misconduct resulting in mistrial. So you can only tell them don't award more than 3 times. And so I don't know whether, again, I don't know their thought process, but they gave me $25 million more than I asked for on compensatories, gave me $30 million less. And again, this was the most reasonable $300 million ask I'd ever made in my career and ever probably will make in light of who I was up against. But the ratio is, it's not even 2 to 1. And, we have Supreme Court authority that says 9x. And so I don't think the ratio argument, the due process argument goes anywhere. I think the whole matzo ball on appeal is going to be they should have never been allowed to talk about punitive damages. They should have never allowed to talk about the cover-up of the data and all of that, which again, Tesla opened the door to.
Right.
And so, we'll see if they want to go the distance at the 11th Circuit, but we're prepared to.
Well, as we come into kind of the final portion of this, one of the things I always ask at the conclusion is whether there's anything that we haven't covered in terms of the organic interview process that you think would be useful for our listeners to know, either about this case or about things in general.
I think the big take-homes for me is trust your instincts, and fight like hell. And when given the chance, which more cases nowadays have the opportunity, develop the big lie. Right? Because here's the thing. You have to prove the defect. You have to prove that there was system failure. But that's only part of the story. And if your focus is entirely on the engineering and the ones and zeros, you are missing a very important part of the narrative. And while Elon Musk is unique in that sense of being such a bombastic blowhard, there are, especially in the digital world we live in, so many companies who overstate so many things about their products and services. Don't lose sight of that, right? And then when you get a case, and it doesn't matter if it's a Tesla case or a trucking case or a slip and fall at the grocery store, right? Remember, in the digital world that we live in, nothing is ever deleted. Nothing, right? When I delete a picture on my iPhone, it's not gone. It's just simply marked as free space, which means the next time I take a picture, it might overwrite it. But it's still there. It gets degraded over time, but it's still there. And that is transferable across almost all case types. It's just transferable across human experience at this point. It's a blessing and a curse. Nothing is ever deleted. And I knew enough to know that. And when you get laughed at, when you get patted on the head, when you get told, oh, counsel, you don't understand, right? I always say it's like med-mal defense lawyers, right? They're like Alex Trebek. May he rest in peace. Oh no, it's not the War of 1812, it's the French and Indian War. Well, screw you, Alex. You're no smarter than me. You just got the answer on the cards. Right? That's these guys, right? That's these Tesla lawyers. That's these auto product lawyers. That's these med-mal defense lawyers. They ain't any smarter than us. They have the answer on the cards. But you know what? Half the time, the answer they got on the cards isn't true because it's just the same bullshit that they got fed by their own client. So trust it. If you think there's something, believe in it and then do what you got to do. Go above, over, around, through. Be willing to go outside the box. They are the box. We have to think outside of it. There are people out there. I see all these posts on listservs. I need an expert for this, that, and the other thing. It might not be a conventional expert. You might need to find somebody through some other means, through Twitter DMs.
Green the only.
You may find somebody. Listen, not all heroes wear capes.
Yeah.
And that guy is a perfect example of that.
Yeah.
And he wasn't out there. You weren't going to find his name on a listserv. You weren't going to get him through some expert searching service. You got to just, get out from behind your desk, man. You got to get scrappy sometimes. Don't be an indoor cat.
Yeah.
Sometimes you got to be an outdoor cat.
Very true. Very true. Well, Brett, I really appreciate you taking the time to sit down and unpack this for all of us. And I'll give an additional thank you because I know how busy you are, both with your practice and also with your service for CAOC and for the coming battles over the next year. And so when you devote this much time to sit down, it's really appreciated.
Oh, well, thank you for that. And I appreciate you giving me this platform and taking the time out of your busy day as well. No, I've got a lot of gratitude for, a lot of people in this world and both with respect on the, the micro level of this case and those clients, of the people I'm, proud to serve beside as we take some of these larger fights, and obviously, to my family and my wife and my kids who, allow me to do what I do, because at the end of the day, the verdicts are great. The political battles are important, but, those are our monuments in this world. So
very true. Very true. And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.